She believes that Dad'll make approximately $250,000 this year, and I'll let her tell the court why, but would be willing to use the number of 125 to err on the side of caution. So we're asking the court to use 125 as the gross. So the guideline child support amount off that gross would be $1,357. And then medical support, Your Honor, would be 235. And then the retro, requesting retro from August 27 to 2020 to today, so 4 years, that number $39,960. So the requested repayment would be $250, Your Honor.
All right, I'm gonna need some really good proof on all those items of the income for the last 4 years, along with the current income. So, tell me, I'll swear Ms. Edwards in. And is there a CSO testifying also?
No, Your Honor.
Okay, all right, Ms. Edwards, raise your right hand, ma'am. You solemnly swear or affirm testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you.
Yes.
All right, thank you very much, ma'am. Go ahead and call your first witness then, Mr. Diamond. Thank you.
Thank you, Your Honor. I call Ms. Edwards. Ma'am, will you say your full name, please?
Ayana Mariama Edwards.
And who's the child that we're here on?
Jamila Andreas.
And were you able to hear the opening I gave the court a few minutes ago?
I don't know what other opening. I've been here for the last 3 to 5 minutes, so I've heard that.
Okay. All right. So let's talk about the possession and access first, and then we can talk about the financials, because I imagine that that's what this is going to come down to. So my understanding is you have no objection to you and Mr. Andreas being named joint managing conservators. Is that correct? And you have no objection to Mr. Andreas getting standard visitation?
Correct.
Okay. And I appreciate that. What are you doing for health coverage for the child?
Medicaid.
Okay. Now let's talk about Mr. Andreas's work. Is it, am I correct in saying that this is not the first time that you've been in court with us?
We didn't make it to court. We were in the Zoom last in June, and he asked for a continuance so he could have time to find health coverage. To my knowledge, he still has not provided any health coverage.
Okay. So you believe he's intentionally avoiding court today?
I don't know. I don't know if he forgot or if he chose not to come.
Yes, ma'am. All right. What does Mr. Andreas do for a living?
He's a general contractor.
Do you know what kind of projects he contracts?
Remodeling, building, housework, all of those, commercial and residential.
Okay. All right. And how familiar are you with his income?
I would say he's not honest with me about it. He boasts a lot. So that's why I said, like, he has told me he will at least clear 250. I don't know if he will clear that. And that's just based on if jobs get completed or not, things like that, because things happen in that industry. So I think erring on conservative is just better.
Okay. When's the last time he told you he was going to clear 250?
I don't know, probably a couple months ago.
All right. So how long were you and Mr. Andreas together?
Our relationship ended in December of 2019. So about 1.5 years.
Okay. All right. How many other occasions has he made, big boast about his earnings?
Every chance he can.
And has 250 been his common refrain?
No, I mean, it's varied. It's on the low end, at least 120, on the high end, 400.
Okay.
And this is throughout the year, so it's always varied. What he's actually cleared, I don't know. I haven't seen, like a tax statement or anything like that. And again, being self-employed, he doesn't get a W-2. I don't go through his documents, never have. So
I understand. All right. And so I told the court that you are requesting a retroactive support. So we're asking to go back 4 years. Is that correct? All right. So my calculation. So, and I should have asked.
I'm sorry. Yes.
Okay. So no, and I'm actually jumping around here. So my request to the court is going to be that the guideline child support amount order be $1,357. Is that number acceptable to you?
Yes.
Okay. And then the retro calculation that we came up with, $39,960. Is that acceptable to you?
Yes.
So the requested repayment, $250. Is that number acceptable?
Yes.
And I think that's what I have, Your Honor. I'll pass the witness.
All right, ma'am, what's the name of this business?
He's had several different DBAs. Currently it's Bluebonnet Painting and Construction, I believe.
And where's he located out of? What city?
Colleen.
You said Bluebonnet what now?
Painting and Construction.
And what other names have you known?
A Touch of Texas Carpet and Floors, and Andreas Renovation Group. He was in Tennessee for about a year, and I think it was Cumberland Construction while he was there. That's the county or the river.
All right, and have you ever been to any of his job sites or anything along those lines, ma'am?
Yes.
All right, and how many people does he usually have working for him?
Average of 3 to 5, maybe.
Okay, and when's the last time you visited one of these job sites?
June?
This year?
Yes, sir.
And where was that site, ma'am?
It was in Belton.
Or where? Where do you know what it was?
Actually, no, it was Temple. I think in the 76504 area. I can't remember the street.
Or what was he doing? What kind of work was that?
It was a full remodel, a full rehab on a house.
Oh, okay.
3,000 square foot job. I'm a realtor. I actually showed that house to one of my clients. So it was a very large property and they were doing a full rehab.
All right. Anything else you went, any other sites you went to this year, 2024?
Yes, I sold commercial land to a client of mine, and he's going to build the bar for them, or at least he was supposed to. Just houses here and there doing small projects, like a bathroom remodel.
Does it do subcontractor work, or is he the main contractor?
It depends on the job site, but a lot of it is subcontracting.
Do you know who he's subcontracted with, any of the big builders in the area? What are we talking about?
No, it's individuals. Like he'll have an HVAC person under him, an electrician, a framer, a plumber.
No, I'm talking, okay, but does he ever subcontract directly from one of the larger builders in the area?
No.
To help on the project? No?
No.
Okay, that's what we're trying to figure out. Find out if we can find a paper trail somewhere if we subpoenaed the records. Okay. All right. And you've never seen his income tax returns or anything along those lines, ma'am? Is that correct?
No, sir.
All right, thank you. All right, Mr. Diamond, any other questions?
No, that's what I have, Your Honor. I'm sorry, I don't have more.
All right, then. All right, then. Here's what I'm looking at, Mr. Diamond. I don't mind going ahead and making this attempt at that amount, but I want him to see what he's been slammed with. Okay, and all of a sudden we'll see whether or not he's going to be as boastful as he has been to mom and probably other ladies too. So yeah, I know how that works. Okay, but for right now, this is the data I've got. This is what he's told her. This is what we're looking at. But before I hit him for $39K and back child support, I want to give him the opportunity to show up and try to explain himself. But for right now, I want to go ahead and set up a temporary order naming both joint management conservators, give mom the right to decide domicile. But now that right's unrestricted, I'll go ahead and order current child support in the amount of 1,000. What was that again? 1,300.
1,357, Your Honor.
All right, cash medical again.
235, please, Your Honor.
Anything for dental?
No, sir.
Okay, and let's reset this with a couple of months out. Let's see if he starts making any type of payments, or we get a flurry of pro se answers, or a lawyer shows up in his behalf, which I have a strange feeling there. At 39,000 and back child support laying on his over top of this, he might actually go out and hire a lawyer. But anyway, let's go ahead and set this up and do it. And let's do a reset for one of the October dates. It's not too crowded. Late in October if possible. If not, that sometime that first week is one of those first weeks in November. And let's see if he shows up. If not, if he doesn't do anything else different, I'll write myself a note and I will grant the $39,000 in retroactive child support. And because based on what he's earning, even self-employed, he's at the max. All right, he's way past the max. Even at 125, he's past the max. So we'll go with that. So is there anything else the state requesting we do here as far as a temporary order is concerned, sir?
Specifically on the return date, Your Honor, it looks like there's plenty of spaces on October the 24th. Would that be acceptable?
That'll work.
All right, thank you, Your Honor. And then I would request that Ms. Edwards, if she can stick around, I'll have this order for her to approve.
All right. Ms. Edwards, again, before I hit somebody with $40,000 in back child support at 6% interest, hey, I wish I could buy a car at that price, but still, all right, we're good. Maybe I can. But the bottom line is, ma'am, before I hit him with that, I want to go ahead and see if he's going to show up and start, singing the blues, something along those lines. So right now, I'm going to go ahead and set everything up, order temporary child support, and come back here in late October. And ma'am, if he doesn't show up in late October, I'll make myself and remind me, because the clerk's going to put a brand new docket sheet on this thing, and I won't see the old one. But remind me, hey, Judge, check your docket sheet. You said if he didn't show up or he doesn't bring some kind of proof, then you will order the temporary order to be the final and grant the requested 39,000 plus and retroactive child support. Okay.
Yes, sir.
All right, let me write that down, Court. Will grant. All right, thank you very much, and I've written myself the note, and we're off the record. Thank you.
Mr. Andreas is asking for more time to get an attorney. Ms. Edwards is opposed. I think Mr. Andreas's position is that I think he either was present at some point in the docket the last time that we were here when we did the default, and there was some confusion about. I'm not doing a great job of articulating his position, so maybe I let him do it. But he's wanting time to retain counsel before proceeding to final. Miss Edwards' position is that this is dilatory, that he's not been paying. And I think dilatory is the word she would use, or at least that's my paraphrase of it. I think, frankly, Your Honor, I think they're both decent people who just don't get along. And I would ask that the court order app close whatever the court does, but I don't think we're going to be able to get this done today. I don't love how long this is taking, but I think there was some confusion about Mr. Andreas being present the last time around, and so given that, I'm not prepared to fight him on getting a reset to go consult with an attorney, even though it has been a while.
All right, Mr. Andreas, sir, where do you live, sir? What city?
I live in Harker Heights.
All right, then. So you local. So I know there are a bunch of lawyers out there that you can get on this matter and get going very quickly enough. So here's the deal, sir. Again, when either party comes before me at a hearing where there's contested issues or issues that the court's going to have to deal with, then I usually don't have a problem with allowing them the opportunity to go out and get their own legal counsel and get their own legal advice. Because, like I say, we're dealing with a 4-year-old matter here that could, at the end of the day, be very, very expensive for the non-custodial party in this matter, and that's you, Mr. Andreas. And ma'am, because of that, Ms. Edwards, the fact is, I don't know at this point. I don't know what the requests are going to be made, but technically, I could be ordering up to 4 years of back child support against this gentleman at whatever earnings he had during that time frame. So as you can see from the last case where we only had a couple of years of unpaid child support, it was $35,000. So again, when I'm dealing with that kind of money, I'm going to dot my I's and cross my T's. And if he wants the time to do it, I'll go ahead and do it. But I will so forewarn you, sir. You need to pay your child support. You need to pay it on time. Otherwise, the court will have the option or looking at doing an enforcement. And I know it takes the state forever to do something along those lines. But if you don't pay your child support, sir, going forward as per the temporary order, the court has the option of appointing a lawyer to represent the child and in this case to come after you for not paying the support. And I will. Understood?
It is understood. Am I able to comment? Or
no.
Okay.
I will let you make a statement, sir. We don't make comments. But
Okay.
I'm not sure why you have my understanding. Mom is claiming you haven't paid, and that's not before me at this point. But for right now, I will let you know if it's as under that temporary order, if you were ordered to pay and you did not pay on time, then the court can actually hold you in contempt. And that's what you might need to talk to your lawyer about that. But I'm gonna give you the opportunity to do all that and try to get y'all back here probably sometime. Well, we're in the middle of the holidays, so that's a problem. And I got full dockets probably until the first couple of weeks of February, and that's when I'm looking at getting you back in here because I can give you almost 60 days, 75 days to hire a lawyer and pay that what's the lawyer's going
Retainer
for $350 an hour these days. So that's up to you. And of course, ma'am, you have the absolute right to go in and talk to your own counsel if you wish to. But based on these circumstances, I'm looking at going ahead and granting it, ma'am. And if and again, I've already warned the father that he has to comply with the temporary order to he and his attorney file something to set it aside or to change it around. But for right now, it's the gospel as far as this court's concerned. So at this time, sir, do you have any questions?
no, sir.
All right, and if you want to make a statement, and again, I could be 100% wrong, and I'll admit it if I'm wrong. If you have paid your child support, or if there's been some type of failure to communicate on that issue. So, is there anything else on that issue, sir?
No, I just had a statement to make in regards to that. Is I'm being asked to make payments based off of a number that I'm assuming Miss Edwards provided. So again, I just it's not realistic for me to. I mean, my income doesn't match what's being asked.
Okay, well, I'll
So
let you and your lawyer bring it up, and we can deal with it. But there's a chance that this was we get testimony in cases from child support officers who have access to, if you live and work in Texas, they have access to your quarterly income tax information, or income information for the purposes of unemployment tax. And I hear testimony on that all along. So again, here's the other thing too, sir. Your paperwork in this case is old as all get out. But under the original petition, you were ordered to present to the court and to the state a copy of your last 2 years' income tax returns, your bank information, and your most current pay stubs. And in of the fact we're in December, I love December pay stubs. I hate January pay stubs. So if you don't have a lawyer, if you have a lawyer, you give him or her all that. If you don't, when you come back next time, you need to be able to turn that over to the state so they can do an accurate calculation of what your child support is going to be. And child support going forward is always based on what you did over the last 12 months. So so what the law is, what you did in the past is a good indicator of what you can do next year. If what you did last year, if it's going to change next year, then we'll look at that next year after it's changed. But for right now, that's what I'll be looking at. But anyway, ma'am, I'm gonna go ahead and see about letting them have the opportunity to seek counsel. I'm gonna go ahead and order that the temporary orders is still full force in effect. And when we come back, if there's still a problem, then I have the option of appointing a lawyer to represent the child. I will. If not, if he's got a lawyer, you have a lawyer. Well, this will go a lot. Technically, lawyers sometimes make things go smoother. So at this time, I'm going to ask you one last time, sir, any other questions or anything else? And then I'm going to come to you, ma'am.
yeah, I do have one statement I want to make, and that's kind of when we broke in June, when we had the first, because we had the first hearing that we had. The understanding was that I needed to go and find health insurance, and she was okay with that. The second thing that she had asked for was $1,000 a month, which again we had agreed upon that was going to be okay going forward in June.
Stop. Yeah. I'm sorry. I hate to do that. Here's the deal, sir. Anything you and she and the state said in negotiations is not something you can bring before the court. That's not negotiation information. Is not admissible in a court of law. All right.
Okay, understood.
So get the lawyer. Let your lawyer come back in and tell the court what needs to be done, and we'll take it from there. Okay. Sorry about that.
Sounds good. Thank you, sir.
All right, Miss Edwards. Anything else, ma'am? What are you at? Anything you requesting we do here today, ma'am?
Yes, I have a question, or I guess clarification. Whether or not he agrees with the number, I mean, some form of child support should be sent. When do we have a timeline on that?
No. Here's the deal. There's a court order that says as of the first day of October, there's a specific amount he has to pay. If he's in agreement with it, if he's not in agreement, it doesn't matter. That's the amount he has to pay, and that's what I'm gonna be looking at when we come back, okay? And that's why I'm letting him know he's got to pay that until he gets that set aside by a formal order of this court. So again, if he sends in if he doesn't pay it in full, then the court has the absolute right at the end of the day to find him in contempt and fine him money and or send him to jail, order him to start serving jail time, okay? But it's left up to an enforcement cause of action to take care of that, and we'll see. We'll cross that bridge when we get to it. But again, Mr. Andreas, if you do not pay those amounts on time, and that means if you don't pay December's child support in full by the 31st day of December, you are in violation of the court order. All right, and that's just the way it is. All right. Next question, ma'am.
Well, I haven't received any. So is that a violation currently?
All right, ma'am. I'm not gonna go into the weeds on this one, but if he for November and October, technically, and then I'll have to have a hearing on it. But technically, he's in violation of the child support order before this court. and an enforcement cause of action can be brought against him for that.
Okay.
All right. Anything else, ma'am?
No, sir. Thank you.
All right, Mr. Diamond, again, I'm looking at doing the continuance. I've already had to make those payments and make them in full. And I've reset this matter. Ms. Walker giving us a date in early February that's amenable to everyone, or amenable to you and the, or to our schedule anyhow. Thank you.
I'm sorry, I've not raised that with the parties. The court has discretionary slots available all up and down the month, though. The court has discretionary slots on the 4th, the 11th, the 13th, the 20th.
Let's get, I want to give him at least, let's see, this is the 12th. So I was gonna give him at least 60 days. I mean, at least, that'll be about 50 days in there. Yeah, I want to give him at least 45 days. So let's go ahead and go with the February 11th, okay?
Yes, Your Honor.
All right, then. So that means there'll be 2 more deadlines for child support to be paid in full, ma'am. And like I said, again, we can take a look at that. And again, when he comes in, if he has a lawyer, obviously his lawyer can tell him what he's looking at. If not, well, we'll do what we have to do. All right. So is there anything else at this time, Mr. Diamond?
Your Honor, if I could get a ruling on my request that the parties be ordered to communicate through app close.
Oh, okay. All right. That wasn't in the temporary order.
No, Your Honor. But based on the conversations I've had today, it sounds like they're going to need that kind of supervision.
All right, then, folks, here's the deal. I'm going to go ahead. Right now, I'm not going to appoint an ad lad to represent the child. I don't think I need it, but when we come back, I can always do that if we're going to not finish this up next time. But this time, I am going to go ahead and order you folks into a parenting app. This is the bold thing to do. Everybody uses the parenting app because I don't have to deal with, well, I sent the message, I've sent the information by Facebook Messenger, but I usually send it by text, or sometimes I do it through app close or whatever, and well, just all of the other things. So right now, all communications concerning between the two of you need to be done in app close, APPCLOSE, Google Play, iTunes Store. It's there, ma'am. You're the custodial party, so you got to download it and set it up, and then they'll forward him the information to set it up once you give that information to them. So so everything else under the temporary order, if you're dealing with visitation, phone calls, access, anything like that, any confirmation that's in that order that needs to be made between the two of you, you need to make it using that app. Is there any problem with that?
That's how we currently communicate. We use app close.
Okay, all right then. Mr. Andreas, we don't do the hand raise, okay? But I'm going to allow you to ask. I will go ahead and allow you to ask another question as soon as I get through with Ms. Edwards. So Ms. Edwards doesn't have a problem with that. All right, okay, Mr. Andreas, question, sir. You're muted. You need to unmute.
Yeah, yes, sir. It's just as far as communication with the child, like there isn't any provisions in there that say
okay
we're allowed to speak with.
All right, then. Okay, here's the deal, sir. If I did not make a specific provision, we'll and that's not before the court at this point. I will. I'm not doing it today. But when we come back, if at the final hearing, if there needs to be specific electronic communications with the child set up, I will do so at that time, sir. I do normally on there when they on weekends where you don't have the child for visitation, and one day during the week I set that up. But normally it's at least on weekends where you don't actually have visitation with the child. But you'll be sure to remind the court of that when we come back in February. If you don't have a lawyer, or have or tell your lawyer to make sure that's part of the package when we finish this up next time. All right.
Okay, thank you, sir.
All right. All right. Anything else then, folks? All right.
Then, State, Your Honor.
I'm going to let the state prepare the order, and we'll get it done. And I'll see everybody in February. Yeah, hopefully that doesn't turn into one of those ice days where we don't, where no one in Central Texas has electricity, but we'll wait and see. Anyway, I'll see everybody then, and until and hope everybody has a Merry Christmas and Happy New Year. And I'll have the state do the reset order, and we'll see everybody on February 11th. Yeah, the 11th, not the 12th. All right, thank you. Brought the record. Looking at seeing whether or not this is going to be a final, or whether or not the court should order Mr. Andreas to provide certain additional financial information. Here's the problem, Mr. Andreas. You were served with a copy of the paperwork. Paperwork specifically says that based on a request for production, you were ordered within a certain amount of time, which is normally 52 days after you were served with that paperwork, to provide the state with copies of W-2s, 1040s, bank account information, so forth and so on. It's called a request for production. And if you did not provide that information, then the court can obviously not go forward with this case. If this was a private case and I was still a private lawyer, I would object to you testifying to anything dealing with the financial circumstances you're requesting, because you did not answer that. That's my understanding. You did not provide that information to the state. And under Texas law, guess what? You cannot testify to anything dealing with money if you did not provide your financial information, period. And I could do that on my own motion, but the state of Texas normally doesn't do it. The AG's office is in the business of trying to get everything done and taken care of, where lawyers are in the business of winning for their client, okay? And believe me, if a private attorney was on this, you wouldn't be able to testify to a word, sir, unless you provided that information. So at this time, I'm going to go ahead and let the state call you both as witnesses. I want to see why the state, let's see why the state is requesting this. And if you have not produced that information, sir, I'm going to give you a date certain where you would need to have to produce that. Otherwise, then we will proceed without you being able to testify, sir. So again, I want to confirm everything. My suspicions are correct on this matter, because hey, if I'm wrong and you produced all that information, we'll find that out real quick, and I will apologize. But for right now, let's go ahead and get everybody under oath. And I'll let the state finish their opening statement, and let you and the mom be called as witnesses, and let's testify to see what we can do here today and see whether or not we can get this thing finalized. So at this time, again, Mr. Stanky, that's my understanding of what you were requesting. And is there anything else you want to add to that at this point before we call the party as witnesses?
Yes, if I may, Your Honor. The state believes that the case should be reset through Mr. Andreas not providing written documentation. I believe the evidence would show that he is self-employed, and that absent him providing some sort of profit and loss or ongoing balance sheets, at least last year's tax form would be dispositive as to how much the income should be. I think the custodial parent is concerned about having to come back to court again, and ultimately, outside of the judge, of you making that decision on your own, if she wants to proceed forward today, knowing that there is limited income information, I'm willing to offer testimony from both parties, but I think it would be in the best interest of the child to have specific documentation. Right now, there's a temporary order that I believe the support was set, from my understanding, with just Miss Edwards' testimony. I don't think there was any Bureau of Labor Statistics or any other information provided. I know Mr. Andreas is concerned about where that number came from, but I think he has to provide some documentation too to say why the number's wrong. I don't think that it was his deliberate attempt to avoid that information, but I think it would be best if the court reset it, continue the temporary order the way it is. The court could always go back and modify the temporary obligation back the past 2 months if the court thinks it was completely out of line with this income.
All right, folks. Well, let's get some testimony from both of y'all, and let's see what we can do one way or the other. Again, I'm not trying to cast aspersions on you, sir or ma'am. I just want to find out what the truth is and what the information is. And I'll give Mr. Stanky the opportunity to get you some questions, sir. Because again, if you're self-employed and not employed, then one of the questions that he's obviously going to ask, and I'm going to remind him to ask, is how long you've been in business and what you do, and whether or not you've applied for any type of loans as far as your business is concerned, or set up credit card accounts based on them, because you obviously had to give financial information for all those items. Chase does not give you money without knowing what you're doing with it. So how are you going to pay them back? So let's find out what's going on here, and I'll see whether or not we can get through today. And again, ma'am, I'll go ahead and let you tell the court why you might not want to come back, or you might want to try to get this done today, but it's still left up to me to make a decision whether or not I feel it's in your child's best interest that we finalize this today, one way or the other.
State calls Ariana Edwards.
Ayana.
I'm sorry, Miss Edwards. Can you hear me? Okay.
Yes.
And what health insurance is currently in place for the child?
Medicaid.
And how old is she?
5.
How long have you had that form of health insurance?
Since she was born.
Has there ever been a time when Mr. Andreas was providing private health insurance where you had the card?
He provided health insurance last year.
Do you believe that that is a stable way for the health insurance to be provided through him?
No, it hasn't been consistent.
Are you asking the court to continue the health insurance provider the way you have it set up now?
Yes.
Now, we talked a little bit about Mr. Andreas's income information. You do not believe that just testimony is sufficient to establish a proper support. Is that correct?
Can you ask the question again? I'm sorry.
Yes, I'm sorry, I wasn't clear. I guess I should say, are you asking the court to make a final decision today on what the support is, or you believe that more information should be provided to make a decision?
I'm not sure. I would just like to not continue receiving zero.
And
Can you repeat that? You kind of echoed on me, ma'am. Repeat that answer, please.
I said, I'm not sure if more information is necessary or not. I would just like to not keep receiving zero.
and what you're referring to is under the temporary order, there have been two amounts that have accrued of $13.57 apiece. So right now the balance is $2,714. Is that right?
Correct.
And he has not sent you any money through other sources like Cash App or anything like that?
He sent me $20 on Cash App to buy our daughter Chick-fil-A.
And how long ago was that?
Sometime last month.
Okay, so that was within the time period when there was a temporary order, is that right?
Mm-hmm.
Okay. In the temporary order, we left open for decision whether there should be retroactive child support. Now, when would you say that you and Mr. Andreas separated?
We have not been together since November of 2019.
And after November of 2019, who left the residence where y'all were together?
He left.
And has he known where you have lived the whole time since then?
Yes.
Did you ever tell him you did not need his help, didn't want any of his money?
No.
Did he send you any money since y'all separated?
He has sent me some here and there.
Has he sent you any items of clothing, diapers, or anything like that?
He's bought some, yes.
What would you estimate the value of those would be?
Over the course of the last 4 years, maybe around 20. And that's including like daycare expenses and everything like that.
Okay, 20 what? 20 how much? 20,000. You think he's been... Okay, I wanted to clarify that. So you think he's
between mostly the expenses of like daycare and things like that, and some of the money here and there, yes.
Okay. And you're asking the court to consider if there should be any back child support for the past 3 years. Is that right?
Yes.
To your knowledge, was he doing similar work then that he's doing now?
Yes.
I'm sorry, real quick, ma'am. Was he self-employed then or working for someone when y'all separated?
He was self-employed then. He's had, I think, 2 or 3 jobs under someone, but for the majority, he's been self-employed.
All right, just trying to get some clarification. Thank you.
Yes, sir.
We'll pass the witness, Your Honor.
All right, be back to you in just a moment, ma'am. Call your next witness, please.
State calls Brian Andreas to the witness stand. Sir, can you hear me okay?
Yeah, I hear you just fine.
Okay. And what sort of work do you do?
General construction.
And do you have your own business?
I do.
And do you have someone that helps you do your taxes?
I do.
Is that a bookkeeper, an accounting firm, or who?
It's a lady who was a bookkeeper professionally, but she's so it's so a bookkeeper.
Okay. Are you the sole owner of that business?
I am.
And do you have any employees?
I do.
How many employees do you have?
About 8 right now.
And have you consistently run with about 8 employees for this year?
I have not. We varied. Like right now we're on larger projects. So, you know, I mean, it varies depending on what our needs are.
Okay. What is the format of your business? Is it a partnership, LLC, or what is it?
So we have filed for an S-corp, but we're not operating under that yet. But what I'm currently under is a sole prop.
Okay, so your income tax that was filed last year, was it
Mhm.
filed on time?
It was filed, I believe, a little bit late because what do we have? Yeah, it was filed a little bit late this year.
Okay, but that has been filed, and if you could, you would be able to get a copy of that. Is
Yes.
that correct? Is anyone else's income on that other than yours?
Just mine, because that would be for last year.
Okay. And if the court orders this, would you be able to provide that with all of the schedules and the indication that that version had been filed with the IRS?
Yes.
Now, your employees, do you pay them hourly?
Well, they're 1099, so it's by the job. So,
Okay. How much would you estimate that you spent on wages for your employees last year?
again, that varies because, it could be anywhere from, depending on the week, it could be 700 in the week, or it could be 5,000 in the week, depending on the job we're on. So,
Off the top of your head, do you know what you claimed as expenses for wages?
so I don't know off the top of my head, and I don't want, I don't feel like I can give you an accurate number.
Okay, that's okay. If
So,
you don't know, I mean, be honest. If you don't
yeah.
know.
Yeah, this is
Okay.
like my first time getting really organized and trying to run it properly.
Now, you have applied for a vehicle loan within the past year, is that correct?
Yeah.
And where was that?
Oh goodness. The Maxdale Auto.
And when you did that, did they offer a credit source, or did you already have financing lined up?
Oh, they offered a credit source.
Okay. And so did you submit that through the dealership credit, the
Dealership.
the manufacturer credit?
The
You know what it
dealership
was?
credit.
Okay, was it Ford credit or was it?
No, I bought an old truck. So
Okay.
it's, I didn't buy anything. It was like a $15,000 truck. It wasn't anything to write home about. So
Now, was there a time that you also were going to buy a vehicle for the custodial parent?
there was time we went and looked at vehicles. Yeah.
And did you ever submit a application for financing for a vehicle for mom?
No.
And do you know what credit union or bank the application for credit went through for your truck?
I mean, I'm sure they did a couple, but I think it was Westlake.
Okay. And do you believe, I'm not trying to trap you or anything or get you in
Mhm.
trouble, but do you believe that the income information that you included on that represented what you were earning at that time?
Yes.
So if you had the ability to get that, or if we subpoenaed that, you
Mhm.
wouldn't have any objection to the amounts?
I wouldn't have any objection. Well, I don't. I don't remember what we put on the application. I know it was based off of whatever the business was coming, but because it was coming through the account, they counted that. So again, it's not a true indication of my personal finances,
Okay.
because of course with my business we own a skid steer, right? Again, that's not necessarily. I mean, I have expenses, is what I'm getting at, in order to
Now,
operate. So
did you purchase the skid steer this year?
I have
And how much do you have to pay per month on that?
$1,100 a month.
And do you have a vehicle?
I have a truck, yes, sir.
And how much do you have to pay on that?
$370.
Where you live, do you have to pay mortgage?
Rent.
How much is the rent?
For me and my wife, it is $2,100.
And how do y'all pay it? Do you pay all the 21? Does she pay all the 21?
She handles that. She pays the rent over here.
Okay.
So,
and do you have credit card expenses that you have to pay each month?
personal credit cards.
How much would you say that you have to pay on that each month?
I don't know, maybe $150, not much.
Okay. Do you have business loans that are revolving that you have to make payments on every month?
No, the only business loan that I would have would be the skid steer, but it's unconventional. It's like a subject to somebody wasn't able to make their payment, so we entered an agreement without the bank. So I essentially am paying his payments for him.
Okay.
Without obtaining credit for the business.
Do you have cell phone bill that you have to pay?
I do, yeah.
How much do you pay for all that?
I believe, including Miss Edwards' iPad service, I paid $307 a month.
Okay. How much do you think that you spend on gas each month for your vehicle?
$300, $400 a month, maybe.
And how much would you believe that you spend on meals every month?
Well, we, because I have me, my wife, and the other 2 children full time, I would say our groceries are probably about $1,000 a month.
Okay. And are there electricity bill that you have to pay?
Yes, sir.
How much would you say that is?
That's normally about $436 a month.
Okay. Are there any other bills that you believe the court should know about to calculate how much your expenses are each month?
I would say, and just for clarification, my household bills are split between me and my wife. So my question is, would I include any of her bills, or would I just include solely me?
Well, I'm asking basically what you have to pay each month for expenses, not what she might pay or what the total is, just what you're paying each month so the court knows.
Yeah, I mean, I'd probably say, I don't know, roughly like $2,700 a month or something like that. So the skid steer wouldn't be considered personal for me because that's out of the business.
Okay.
So I just want to make sure that that's not included in my, in my finances.
Okay. So now, when you filed your income taxes for the last tax year, I think you estimated what you thought the gross income was on that, if you remember. Do you remember what that was?
It was like 57,000.
Okay. And was that your total gross sales, or was that after you deducted expenses?
So that would have been my personal income tax.
Okay. So your personal income tax of 57, that includes only the money that you paid yourself from the business. Is that correct?
Yes.
So do you know what your gross sales were from the business?
I don't know off the top of my head. I'd have to, because again, a lot of different numbers, and so.
Okay. And so you're in charge of setting your salary, basically, depending on how much that comes in. How much would you say that you're paying yourself each month from your business?
Yeah, I'd say between like 4,500 and 5,500.
And the temporary order had a gross income that was twice that much.
Mm-hmm.
Do you think that number is incorrect?
I do feel it's incorrect.
Now, do you think that you could, if the court allows it, that you could get together information regarding your income tax and loan application to make sure that the correct child support is set on a final basis?
Yeah, absolutely.
You have one other child, correct?
So I have one other child that we have an attorney general case for that I have sole custody of, and then I'm in the process, like I said, of adoption for my stepdaughter. And then we're unsure if we have one on the way or not. So
okay. And the adoption may be completed in 2 months, possibly.
Yes, sir.
Okay. Those are all the questions. Oh, let me ask you. You said you weren't exactly aware of the initial obligation because there was some problem with connectivity or whether you were participating in that temporary hearing. You understand right now, rightly or wrongly, the balance is $2,714 on those 2 payments. You understand that?
Yeah, yes, sir. Okay. And am I able to add to that?
Yes, go ahead.
Okay, so just when I called in for the Zoom again, when I wasn't able to be connected, I guess because whatever time schedule was off, they basically just told me that court was reset, so I didn't know that we had an order until after the fact. I just was notified that the schedule changed, and I just assumed first, third, fifth weekend, so I wasn't even aware that I was entitled or allowed to get her on Thursday evenings. So, that was a mistake on my part.
So what happened, basically, without going too much into it, y'all had an agreement where you're doing your own visitation at some point, and then now there's the standard possession order. That's the extended one where you're entitled to Thursday evening to when school starts Monday, correct?
Yes, sir. We had a week on, a week off was our schedule. And we even had a notarized form when I was working for a different company prior to being fully self-employed.
Okay.
And I don't know if y'all have a copy of that original support that her and I had notarized, but it was showing that we did joint custody. It was a week on, a week off. And then, like I said, I just assumed it was first, third, fifth weekends. The attorney, I'm sorry, real quick, kids. So I had, basically, I'm sorry, I'm trying to not interrupt with the children in the background. But yeah, I didn't, we went from one to another, and yeah, I'm just a little confused, you know, I guess, on the back child support, because I think we even operated in a capacity where she filed my oldest on her taxes for a few years, because we financially operated together, and he's always lived with me, so I don't understand how that wouldn't be considered into this determination here.
And is it correct when the mother says that she thinks that you paid with childcare and other things about $20,000?
I'd say it's probably a little bit more, because again, I incurred expenses while she was in my care during those week on and week off. I know, you know, there's been a couple times.
Sir, so you can only count monies, things you gave her, not expenses while the child was with you. I'm sorry, thank you.
Those are all the questions I have, Your Honor.
Mm-hmm.
Okay. All right, be back in a moment. Anything again of the mother at this time, Mr. Stackey?
Nothing else, Your Honor.
All right, sir. How long do you think it'll take you to get a copy of that your tax return and a copy of that loan application you did for the new vehicle, sir?
Yeah, I would assume 10 business days. I think that's kind of the standard anytime we do a request. So I'd probably ask for 3 weeks in order to make sure that I can send a certified copy of something, certified mail to whoever I'm needing to send that to, and then get a response.
Okay, and your bookkeeper, do they have their own firm, or they work for somebody? Or
no, they're working for themselves right now, because there's a smaller.
So that one you can get fast, but the other one might take a while, right?
Yeah, yes, sir.
Okay.
Yes, Your Honor.
All right then. All right then. And real fast, sir. How much have you given the mother in cash or in cash payments over the last 90 days?
We haven't done any cash payments over the last 90 days.
All right, so there have been no funds there over the last 90 days?
No, sir.
All right. And as far as the child being with you over the last 90 days, what time frames are we looking at? Weekends, that sort, what are we talking about?
Yeah, so in the first 30 days of the 90, we did a week on, a week off still, to my recollection. And now it is the standard visitation. So it's the first, third, fifth weekends. And now that I'm aware that Thursdays I'm entitled to as well, and even then I'd like some clarification, and not to mince it, but I wasn't under the impression, the way it reads, that I'm able to keep her until Monday when school goes. And that's what the gentleman was telling me in our breakout rooms. So I'm still not fully understanding the schedule that's ordered.
All right, so again, I wish I could give you, if you want some, obviously you want some legal advice or some legal interpretation, you probably need to run that by your own lawyer or by someone who's knowledgeable enough to give you that information, sir. But again, obviously the standard possession order for people who live between 1 and 50 miles may be, in your case, be the appropriate possession order. And if you need that explained to you, someone from the state might explain it to you, but if you want to be sure that you understand everything, you have specific questions back, and it might take a while, then you really might need to speak to your own lawyer about that one way or the other.
Okay.
But the bottom line is, I'm probably looking at doing a reset. I'm probably giving you the opportunity to get that information. I don't want you to pay it. We're not asking that you pay a dime more or a dime less, but we will be looking at that, sir. And again, I know you were testifying that you and the mom had an agreement, notarized and everything. But unfortunately, like I said in my opening statement, unless it involves someone in Bell County with the name judge in front of that agreement, it's not worth the paper it's printed on, sir. these items are governed by the Texas Family Code, which means it takes a family law court to actually make a binding order or an agreement in these things. So if there's something you specifically want to ask the court to do, sir, you obviously have the right to do so, but it has to be right now. The only thing I have before the court are the pleadings that have been submitted by the state, and those have pretty much been at mom's behest for mom's benefit. So if you want something separate, you got to follow what the rules say. And of course, if there's something that you want as far as a clarification at the final order, I'll be happy to try to help you with that, sir. But there's nothing like having your own counsel on this. So but anyway,
Okay.
right now I'm looking at going ahead and ma'am, doing a reset. We need to get a copy of his information, because my understanding is that you're asking for retro. And sir, if you've got dates certain that the child is actually living with you for 1 week on and 1 week off, and you got proof of that, or you got testimony on that, and the mom will verify that testimony, then obviously I can adjust your child support appropriately to cover only the times that the child was with mom. Because again, that's what I'm allowed to do. So
Okay.
So y'all need to sit down and do the math, and sit down and do the calendar. I'm sorry, and figure out all this. And I want to give Dad a month to get his paperwork and ducks in a row and come back and where we can finalize this thing. I really hate to put y'all back on a general docket, but I don't have any special settings to December, and it might not be to December before we get back in here anyway. But right now, it'll either have to be a general docket, because again, right now I don't think I have anything as far as special settings concerned because of the holiday time frames. Okay, so now this is not there. So you're probably looking at a general docket, and what was the date the state would be looking at coming back as far as getting and making sure that they had the information necessary?
Whatever time that Mr. Andreas needs, I'm fine with that. And if I need to talk to legal tech about the actual date, I don't have the available dates in front of me, Your Honor.
All right, then. Well, I know I got general dockets all over the place, but the next one that probably fits in his schedule. So, when they say 18, 20 days, I always give them 30, because you're dealing with huge corporations. And again, next month is Thanksgiving, Veterans Day. So there's going to be lots of closures. So I would be looking at December. And like you told him, I could always do retroactive it back down to the correct amount, whatever the child support should have been when I made that original order. And that can cover November, December, August, whatever the dates of that month were that were covered. All right, well, let's do Thursday the 12th then. All right, you'll need to get and like lawyers do, I'll ask that you get that information that's been requested to the state, and the state and Mr. Sank will get you back in the breakout room and tell you how to the address to send that to. The state has its own clearinghouse for email attached information that they're requesting in cases where that needs to be sent, and I'll ask you to get that done and sent to him on or before the last day of November, which is the 30th. Okay.
Okay.
Your Honor, if they can go ahead and be excused, I will submit that information in the reset and send it to him via DocuSign.
All right, good enough. So one final time, Mr. Andreas, questions or anything else, sir, you think I need to know at this point?
I do have the question, and that was in regards to her filing my oldest on income tax. Is that relevant? Because again, saying that we didn't operate together.
What's the question? I'm sorry.
Well, with her filing my oldest on the income tax, even though wouldn't that be relevant to show that that we were financially intertwined? Because why else would somebody claim a child?
It may be, sir. So, but you need to get those dates and times. And if you're saying that those were payments that you gave her in lieu of child support, then
no, sir. That's not what I was saying. I just was saying because we were functioning, but financially, there was we were intertwined, even though we weren't married. We were still on an on and off basis, and but now that I'm married, it's now we want 3 years of back child support.
Okay, well, sir, if you could show during that time frame that y'all were together, then that'll work. Or if she's asking for child support for that time frame, and those were the funds that they were your funds that you allowed her to get based on that, it's kind of problematic based on income tax, because again, it's really the dependence and the amount she got back would be a lot of that would be dependent on her income and her sources and what her deductions were, so forth and so on. So we would need to get that information. So again, you're the first person I've ever I've been doing this for 20 years. And I never heard of anybody doing that before, giving their tax deduction to a child that's not theirs to the other person. And so I don't know. There's not a criteria for that. I'll figure one out.
Okay, well, sounds good. I just, I feel like it's relevant because again, saying we were completely
Okay.
strangers.
Well, we'll figure it out, sir, and
So-
I'll try to figure out some property. Judge's background is his college background is business administration, finance. So yeah, we'll figure it out. All right.
Yes, sir. Sounds good.
All right. All right. Ms. Edwards, anything else, ma'am, at this time?
To clarify, as far as the retroactive child support, I was not including the roughly year that we were a week on and a week off, because you
Okay,
can
well-
go back 4 years and I only asked for 3. So just to
Okay.
clarify.
All right. Well, again, if that's the time frame is, but get your calendars out, folks, because when we get testimony on that, you can ask the court for permission. Well, look, can I check my my documentation for the calendar? And you can actually give me dates, times, everything, 100% where we can get it down pat. All right, ma'am. But I understand that you're saying that, and you're letting him know at this point that that's not inclusive of the time frames what y'all were doing 1 week on and 1 week off. And you can confirm that, and we'll move on with that. All right. Thank you.
All right, you as well. Thank you, sir.
Thank you.
All right,
Thank you,
Ron, we're ready
folks.
to go. Thank you.
Mr. Andreas and Ms. Edwards, you can hit leave meeting. Enjoy the rest of your day.
Okay, and just to clarify, y'all do have the ARG. That's the one I'm docu-signing for right now?
Yes,
or-
sir. Yes, sir.
Okay, sounds good. Thank you, sir.
And this matter is before the court on a motion withdrawal. The court will know for the record that Mr. Chad Southworth is attorney for Miss Ayana Edwards is requesting the opportunity to withdraw as counsel on this matter. Mr. Limberski is representing the other party at this time. Court will also note, I think this is one of the ones that was being transferred to district court, but my understanding is that the court, based on that transfer, the district court wanting mediation to be completed first before there was a hearing before the district court. So at this time, like I said, we're before me on the motion to withdraw. So I obviously will let Mr. Southworth make his motion, and Mr. Limberski can and the state can contest that, or the mother, I'm sorry, your client could also contest it, Mr. Southworth. So you might have a little 3-on-1 break going against you there, sir. But anyway, I'm sorry. Basketball season's over with. Never mind. We won't make that. We won't make a basketball reference anymore. But anyway, at this time, sir, it's your motion. So I'll have you bring that motion to tell the court what you're requesting to do, and then I'll have the state and Mr. Limberski make their responses. Thank you.
Thank you, Your Honor. My client and Mr. Limberski have both signed the motion to withdraw. They have no objections to it. I'm trying to minimize the cost to my client. She doesn't necessarily need me to go to mediation or things like this. She does need me for the final, if it's going to be a contested final. She is a single mom, and unfortunately, even though this case has gone on for 4 years, she's still waiting to receive money from the opposing party. So she does not have the funds to just keep throwing at attorneys all the time. So I am requesting a withdrawal to minimize her cost. I will get back on if it's absolutely necessary for her. But right now, she does not have the money to just keep throwing money at me. That's all I have, Your Honor. We're also requesting that, like Mr. Limberski, that this do get transferred to district court as is, and that we will be going to mediation. She will be with Mr. Limberski.
All right, Mr. Welch.
Your Honor, so I guess first things first. Previously it was the motion to set hearing on motion withdrawal was on file. It looked like Mr. Southworth's motion to withdraw that he earlier filed was rejected, but he has filed a new one. The state and Mr. Limberski agree, I believe, to waive defects in service and notice and all of that to get it before the court today, and state defers to the court on the withdrawal. We don't object to it. We'll ask for you to decide on that. And Your Honor, as for we were thinking, Your Honor, essentially of non-suiting or pleading our original petition in suit affecting the parent-child relationship, AOP, as an automatic way of getting it to district court.
It's already been it was already being transferred to district court, Mr. Welch. It was just that under the district court's rules, before they'll take it, they had to at least attempt mediation.
Oh, so are you signing Your Honor, there was on file an order transferring. You did not sign at the time. Are you signing that one then?
I'll go ahead and end up signing at this point. I'll confirm, but I'll have to have one that that they still are to go to mediation before they can go to hearing either final or temporary hearing at the district court level, and I'll run that by the district judge. But I'll look at going ahead and signing off on that and admitting it to say that. But I'll get Mr. Limberski's feedback on that in just a moment. Does the state have a problem with that?
No, Your Honor, as long as the state's not involved in any of the mediation.
Okay, yeah, obviously y'all don't do mediation, but wouldn't hurt you, Mr. Welch, to sit through a couple of those as a lawyer. But you know, I know y'all's policy. Okay.
Thank you, Your Honor. And
all right, and I see Ms. Golder's here for. Are you here for in support, or do you have a? Are you in on this bailiwick?
I'm on another matter, Your Honor.
Okay. Just want to make sure.
Yes.
All right, thank you. All right, Mr. Limberski, then do you have a problem with the court doing that, sir?
Well, Judge, first of all, I do not object to the withdrawal. As far as, you know, you had ordered mediation before, obviously that's when Mr. Southworth was on the case. Usually, and we have cases where the other side does not have an attorney, we usually have filed a motion. Because one, most mediators will not mediate.
Yeah, I know.
Say, so we would be asking
Mr. Limberski, is that me or you? Are you on a tugboat somewhere, sir? Because I'm getting this.
I had to be on my cell phone. I had an incoming call, but I got rid of that. So
okay, that was the phone buzzing. Okay, sorry. Thank you.
So we would ask, you know, at this point to waive mediation. And then
I'm gonna send it over to the district court and let y'all have that mediation hearing with him. Okay.
That's fine. Yeah, as soon as it gets to
I'll let Judge Russell decide how he wants to handle this. But I'm looking at doing the transfer. I'm looking at, but I know Judge Stem used to do mediations with pro se litigants. He might have wised up on that choice. So, but anyway. I'm looking at doing the transfer, but the mediate I'll need to set it for a hearing. I'll ask the district judge to set it for a hearing on the mediation. All right.
Okay. And so we had a hearing set in front of you on this case again in August 8th, I believe. So that setting will go away.
Yes, sir.
Okay. Right. Thanks, Judge.
All right, I'll contact Judge Russell and we'll coordinate everything. And you'll have to run it through the court coordinator over there as far as that's concerned. But I'll ask him to do an order setting this for a hearing on whether or not the mediation should take place because there's no longer counsel on one side. All right.
Thank you, Your Honor.
All right. Well, thank y'all all very much, and I'll sign off on that transfer order, and I'll get a hold of Judge Russell's office, and hopefully we all have something concrete by early next week. Anyway. Thank y'all all very much, and Mr. Southworth, you can send over an order allowing you withdrawal, but leave some spaces in the send out an order. And if I can, I'll add something specifically to it, or I'll do my own separate order, making ordering that and having the Judge Russell set up the mediation hearing. All right.
Thank you, Your Honor. We've already submitted it this morning. I don't know if it's in your queue yet.
All right, then I'll take a look for it. Then, thank you. All right, everybody. Thank you very much. Everybody have a safe holiday. And if there's nothing else, we're off the record. Thank you.
And thank you, Your Honor. And so the state is not non-suiting then, just to make that clear.
Right. Understood.
All right. So Mr. Bursky, Mr. Southworth, doesn't look like there's anything I need to draft. So y'all are free to leave.
Thank you.
Thank you.
Thank you.
Have a good one, Your Honor.
Thank you. Let me finish writing this one up and I'll be right back.
Thank you, Your Honor.